What ended up happening as we proceeded through discovery, though, was that we realized that we were dealing with not only a medical malpractice case, but also a discrimination case. When we started going through discovery, we knew that we had a rock-solid liability case. Dan showed you the medicine. We talked to our experts. They supported us. The doctor says 2 to 3 days you need to follow up, yet the nursing instructions said follow up within 1 week. And as Dan explained, by the time the child got to the hospital, his bilirubin level was so high and the brain damage had already been done. So what we wanted to do in discovery then was to figure out, how did this actually happen? We wanted to look at the communication process. And the way that happened was by deposing the nurses that were involved in discharging the family. At Tri-City Medical Center, they have a combination of both registered nurses and certified nursing assistants. Now, the registered nurses are the licensed professionals that perform the discharge teaching. The certified nurses assistants help out the registered nurses, but there's actually a California Business Code section that says that the CNAs are not allowed to provide this discharge teaching. And she testified that it's her responsibility as the registered nurse to look at the doctor's orders, to take those doctor's orders, and then to communicate that to the family. But what she also told us in her deposition was, at that point in time, because she didn't speak English and because the Santiago family only spoke Spanish, she called a nurse's aide to come over and to provide that discharge instruction. Now, to be clear, this wasn't a situation where the registered nurse walks into the patient's room with the CNA and then says line by line, which is subsequently translated to the family, these discharge instructions. We learned this through Ms. Rivera's testimony. In fact, what had happened was the registered nurse gave the discharge instructions and the paperwork that Dan showed you directly to the CNA and said, basically, send this family home. So again, the CNA is not merely translating what the RN is saying to the family line by line, but is officially giving the instructions to the family herself. A job and a responsibility that she is not allowed to do under California law. As a CNA, they're not responsible for going back and taking a look at the doctor's orders to confirm exactly what the doctor wanted. Had that been done in this case, as the RN was supposed to do, she would have seen that Dr. Miller wanted this family to come back in 2 to 3 days and not 1 week. Not only did she testify that it was her routine, what she told us was that this was the custom and the practice of the hospital itself. In effect, what was happening was the English-speaking patients were receiving the discharge instructions from the RN, an RN who is licensed and who knows that she has the responsibility to go back and check the doctor's orders, while at the same time, the CNAs were providing discharge instructions to Spanish-speaking families who were not licensed, well, the CNAs who were not licensed and were not trained to go back and confirm the physician orders. What we saw was this disparate and inferior care that was being provided to the Spanish-speaking families, or families of limited English proficiency.